unit or some other type of supervisory program with zero tolerance.
In today's case, we meet Briella Butler, a young woman standing before Judge Stephanie Boyd, facing the consequences of a probation gone wrong. Butler was originally given a second chance through deferred adjudication for forgery of a financial instrument. Basically, the court pressed pause on her conviction, letting her prove she could stay clean and crime-free. But that grace period just hit a breaking point. Now she's back, pregnant, facing a possession charge for meth, and one step away from losing her freedom. The state is pushing for 18 months in state jail, while her defense fights desperately to keep her on probation. Judge Boyd isn't convinced that another chance will help, and as the hearing unfolds, things get emotional fast. But here's the twist: this case isn't just about drugs. It's about accountability, addiction, and how far a judge will go to save someone from themselves. Stay locked in, because this courtroom is about to get real.
I'm sorry, Briella Butler.
Good morning, Your Honor.
Good morning. All right, the court is calling 2024 CR 4982, State versus Briella Butler. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Patrick Clowns for the defense.
And are you Ms. Butler?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Briella Butler who's placed on deferred adjudication in 2024 CR 4982 for the offense of forgery of a financial instrument on February 12, 2025 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violate condition number one, on or about the 22nd day of May 2025 in Bexar County, Texas. The defendant, Briella Butler, committed the offense of possession of a controlled substance, plea group 1, in violation of condition number 1.
How do you plead to that, true or not true?
True.
I'm sorry, was that true?
True.
Thanks, ma'am. We'll waive the remaining violated condition, Your Honor.
Yes, sir. Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
No, Your Honor, it's unagreed.
All right, state, what are you requesting?
The state is requesting adjudication of guilt and revoke her community supervision for 18 months in the state jail facility. One part of the agreement, we are taking into consideration the possession case she just pled to, which is JN 7143967, and we're also taking into considerations a county court at 2 case 2025 CC 011626, which is a failure to ID.
All right, in defense, what are you requesting? Oh,
Your Honor.
you can't sign it.
Well, this is the
This is, okay.
Your Honor, we're requesting that you continue her on probation, to deny the motion, and to follow the recommendation by probation to send her into the MIC unit or some other type of supervisory program with zero tolerance.
I really don't normally do zero tolerance in this court because being on probation, you're supposed to follow the rules. So my question for you, or maybe for her, what have you done? Because you've been on probation since February. What have you done? Have you completed? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Briella Butler.
What have you done?
I went to the 60 days NA or AA online virtual visits. I reported twice.
All right, so that didn't work because you're here for a possession of controlled substance. What was that controlled substance?
Methamphetamines.
All right. So we know that doing the 60 days didn't work because you have a possession of meth. And how far along are you in your pregnancy?
7 months.
All right. So what that means is you're doing drugs.
No, ma'am, I wasn't.
Who did the meth belong to?
DeAndre Hartley. I have an affidavit that they brought in.
Mm-hmm.
It wasn't mine. I did stay at the scene when the cops came. my car, I just bought it, it was broke down, and I was at my mom's house, and cops pulled up, and when they pulled up, my friend ran off, and they immediately put me in handcuffs and searched the car.
So let me just tell you right now,
And
the only way you're going to be continued on probation if you go into inpatient treatment. We're not doing this zero tolerance thing. So she can either go into inpatient treatment, and because you're pregnant, they will accept you at SAFEP, but they're not going to accept you at any of the programs because of how far along you are in your pregnancy. So you can either do that or you can do the 18 months.
okay, thank you. Can I take my baby with me?
No, what ends up happening when you are at SAFEP, because it's at the prison.
This is where everything hits hard. When Briella, 7 months pregnant, asks if she can take her baby with her to treatment, Judge Boyd drops a reality check that cuts deep. SAFEP isn't just a rehab. It's a state-run in-custody treatment program inside the Texas prison system that means Briella will serve her time while pregnant, and once she gives birth, Child Protective Services steps in. Unless a family member can take custody, her newborn could go straight into the system. It's one of the toughest parts of cases like this. The law has to balance compassion with consequences, and Judge Boyd's response? It's firm but layered with humanity. She offers treatment instead of 18 months in jail, but the message is clear: this is the last chance. What do you think? Should a judge show leniency to a pregnant offender, or is it time for accountability? Let us know in the comments, because this one divides opinions.
When you're at SAFEP and you deliver your baby, someone needs to be there to accept custody of your child. Otherwise, Child Protective Services will be picking up your baby and you will have a CPS case. And when you're released from SAFEP, that's what will happen. You will have to do parenting classes and everything else that's required of you. And when you have somebody, if you have your mom or whoever it is to come pick up your child at the prison, they will make a determination on whether or not that person is appropriate or not. All right. So the court will deny the motion, alter and amend conditions to include SAFEP. Probation, is there anything you recommend other than SAFEP? I'm sorry, what? All right, so there'll be SAFEP, and that's, of course, is in custody. And then it is 9 months. And you have to wait. What's the wait time for SAFEP?
So in the end, Judge Boyd denies the motion to revoke probation, but adds a strict new condition: Briella must complete the SAFE program, spend 9 months in treatment, and wait up to 3 more months in jail before transfer. When she's released, her probation continues with tighter supervision, parenting classes, and no unsupervised contact with minors. It's a sentence that's both punitive and rehabilitative, showing that Judge Boyd believes in accountability with a path to recovery for Briella. The message is clear: if she wants to keep her freedom and her baby, this is her final shot. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal insights every week.